that a condition could be factored into the order to the effect that CPS may present to SASSA the additional expenditure, for want of a better terminology, that would make it possible for it to be able to continue with to continue rendering the service without milking the system in any manner whatsoever, subject to appropriate monetary mechanisms. What about that?
Chief Justice, what you'll know from our affidavit is my client has said, in relation to any interim contract that may be concluded after the 1st of April, it has no objection to the exact same mechanism that this court ordered in All Pay 2. So at the end of the interim contract, in the interest of transparency and openness, it must give up its financials, it must show its income, its costs, and its profit. It has no objection to that. We've said as much on affidavit, Chief Justice.
No, my question is narrower. Instead of agreeing with SASSA in advance on an amount that has not been subjected to scrutiny, how about continuing on the old terms, subject to the possibility for CPS to make written submissions, maybe it's too legalistic, making representations in relation to the reasonable more that it needs to operate well, on the understanding that you'll be having, say, the Auditor General there and maybe the Public Protector, if deemed necessary, to check whether the system is not being milked, to check, and I know it's colloquialism, to check whether or not the amount, yes, is reasonable.
Yes, Chief Justice, sorry, I misunderstood your question and I apologize for that. I believe it was actually the proposal of my learned friend, Mr. Breitenbach, this afternoon. And this is what I wrote down. I understood our learned friend for SASSA to say this: the contract would continue on the old terms and on the same price. And what my client could then do is motivate after the event for what a reasonable increase would be. Everyone else would then have a chance to chip in and make their submissions. And what SASSA then proposed, Chief Justice, is it then comes before this court, and this court then decides what my learned friend referred to as what would be fair and reasonable remuneration. And our only objection to that, Chief Justice, with respect to our learned friends, is that is not the job of this court.
How about the Auditor General, the one who bears the constitutional responsibility to ensure that there is no abuse, being the one to advise the court? I'm just thinking aloud on the appropriateness or otherwise of the more that should be paid.
Chief Justice, this is our difficulty, and I hope I am answering your question if I answer it this way.
Or even Treasury.
Yes. My client enters into those negotiations with SASSA, and you'll know from the papers what the something more is. My client says, if that were unreasonable, why would SASSA have consented to it? Since on the face of it, it's not a large increase. It's the same price plus CPI going forward. And so what my client says is, it doesn't understand why someone else has to second guess the exercise of contractual power.
No, but if SASSA is confident about the correctness of what it did, it shouldn't be bothered about what other opinions are going to be expressed. At the end of the day, would Treasury now, another government department that bears the responsibility to ensure that there is fiscal discipline, would it say something reasonable is unreasonable?
Yes. No, it wouldn't, Chief Justice. Our only difficulty is why we need the additional layer. And so what we say is SASSA sits opposite us during the contractual negotiations. I understand our learned friends to be saying this, sotto voce. They're saying, well, maybe SASSA agrees to an unreasonable price because something corrupt is happening backstage. But Chief Justice, if there were any corruption in forming the interim contract, that contract would then be vitiated, and we accept that.
Yes, but so in principle, you're not opposed to the proposition that the Treasury should have a say or the final say on the appropriateness or otherwise of the more, if the more is to be paid?
Chief Justice, I think to responsibly discharge my job, I must ask for an instruction in that respect, because ultimately that's not a question for lawyers, that's a question for whether the client would be acceptable to it. But I can ask my client to furnish me with an instruction. But for the moment, Chief Justice, I wonder, could I continue with my submissions? And I promise I'll come back to that. It's a critical issue.
I'm sorry, Mr. Cockrell, I want to stop you before you go there. If we're against you, in regard, you say for us to make that order wouldn't be just and equitable. If we're against you and we make that just and equitable order, that would then create lawful obligations that must be complied with by your client, by SASSA, and by whoever is involved. Would that satisfy, I think, your fourth proposition?
Yes, subject only to this, Justice Froneman. It's a submission I was going to make. But let me make it, well, Justice Froneman, can I answer it this way? It's a slightly circuitous answer, but it is necessary for me to sketch the various permutations. So can I answer your question this way? We understand the debate before this court to be as follows. What can happen after the 1st of April? And the court has floated two possibilities in the course of the debate today. One possibility, my client can extend the existing contract, the old contract, the invalid contract. Second possibility, it can conclude a new contract that will apply with effect from midnight on the 1st of April. That's our understanding of the two possibilities that have been floated by different members of the court. Our submissions regarding those two possibilities are this. If the court were to direct my client to extend the existing agreement, it's going to have to change the order of suspension in all pay 2. Because on the face of it, at midnight on the 31st March, the order of suspension kicks in and it invalidates that contract. And so my client couldn't extend it. And so in response to Justice Froneman's question, would that put my client's mind at rest? Well, it wouldn't in relation to an extension of the contract, because the extension would be unlawful unless the suspension order is varied. And with respect, this court couldn't vary the suspension order in all pay 2 because all pay is not before it today. It would at least have to hear all pay on that. So Justice Froneman, that's the first possibility. Would my client accept the legality of a direction from this court to extend the old contract? With respect, my client would certainly have doubts about the legality of that, because once the suspension order kicks in, the contract self-destructs and it's caught in a vicious circle. That's the one possibility. The second possibility is, well, don't extend the old contract. Simply direct my client to conclude a new contract with SASSA with effect from the 1st of April. And I think, Justice Froneman, that probably is the possibility you were putting to me in your question. And your question was, would my client accept the legality of that? And the answer is this. In the case of a new contract, this court wouldn't have to vary its order in all pay 2. Because the old contract dies at midnight, nothing has to be varied. The only problem with the new contract would be that it wouldn't comply with the procurement requirements. But our understanding of what SASSA is saying today is, if this court directs the conclusion of a new contract, the fact that there is no compliance with the procurement requirements would fall away. And if that is correct, then the answer to your question, Justice Froneman, would be yes, then we would accept the legality of that.
Well, I'm interested in your submission on that. Can we, as it were, step in and take over an issue, an order that effectively creates, or whatever one wants to call it, a contract without the involvement of the procurement legislation and requirements?
So it's not just procurement legislation with respect. The procurement hierarchy starts with Section 217 of the Constitution, which requires there to be a system in place which is open, transparent, competitive, and various other things. Under that, we then have the PFMA, and under that, we have the various regulations that have been made by Treasury in terms of the PFMA. And under that, we have an instruction note that Treasury issued. And it's the instruction note of 2016-2017 that has been the sticking point for SASSA, as we understand it, Justice Vroneman. Because the instruction note says you can't deviate from a competitive process unless Treasury authorizes it. And so, Justice Vroneman, the short question you're asking me, as I understand it, is if this court were to direct my client and SASSA to conclude an interim contract in circumstances where there has been no compliance with the Treasury regulations and the Treasury instruction note, would that override those requirements? And we would respectfully submit that it would.
I'm sorry, Mr.
I hope that
Cockrell.
answers your question. It was a long way of getting there, but that ultimately is the answer to the question. Yes.
Mr. Cockrell, let me just clarify this point. You're saying the court cannot give an extension because all pay is not involved. Now, what would be the basis of ordering a new contract, if not the exercise of Section 172 powers, which links us back to all pay too?
No, Justice Jafta, I'm sure I was unclear. The reason why, with respect, it wouldn't be competent for this court today to vary its order in all pay 2 is simply because it hasn't heard all pay. In other words, all pay is not a party before it today. So all pay is the beneficiary of the order of this court's judgment in all pay 2, and all pay may have something to say. So our point is purely a process one, that in order to amend the order in all pay 2, one would at least have to hear all pay. But on Section 172 of the Constitution, we accept there's no need to hear all pay on that.
Is all pay not required to be heard when we're considering a new contract?
No, with respect not, because all pay won the litigation, if I can put it bluntly. It got the order in all pay 2. At the end of 5 years, that order comes to an end and the order of invalidity kicks in because the suspension falls away. So all pay has no interest in what happens after the 5 years. Its interest was in the order of this court, which will cease to apply at midnight on the 31st of March, with respect.
I'm not sure whether I follow that. Wouldn't that bring us to the problem which was raised by my brother Madlanga earlier on? That how can we make a contract for the parties?
Just
The whole thing was anchored on the process flowing from all pay to. And the court said, we are here now, there's a problem, it needs to be sorted out. We're going to exercise our power in terms of 172, continuing from all pay to.
We wouldn't dispute any of that, Justice Jafta. What we would say is our process point, which is that all pay has to be heard, with respect, wouldn't apply if this court were to direct my client to conclude a new contract with SASSA with effect from the 1st of April, because the order of this court has by then done its work, or at least it will have done its work by midnight on the 31st of March. The reasoning, of course, would continue to apply, but all pay has nothing to say about the reasoning in the judgment that it secured. Its interest is in the order it secured.
Given CPS constitutional obligations beyond the contractual period, can it simply close its eyes and say, even if social grants are not paid, I'm not going to do anything?
No,
Supposing the negotiations are not successful by the 2nd of April or the 1st of April, will it not be incumbent upon CPS, wherein there's constitutional obligations that it has accepted, to do something?
Acting Deputy Chief Justice, it's an important question, and may I answer it? I emphasize the difficulty for my client is it cannot discharge its constitutional obligation on the 1st of April unless it has a contract with SASSA. It's quite unlike other obligations. Other negative obligations wouldn't require a contract with anyone. Other positive obligations to provide medical service to someone in a critical condition also wouldn't require a contract with anyone. But here's the difficulty for my client. On the 1st of April, it can't pay the 11 billion rand unless it gets the money from Treasury. And Treasury won't pay it the money unless there's a contract in place.
But supposing, let's not anticipate what Treasury will say. In the event money is made available, will CPS carry out the obligation?
If it is able to discharge it, it will, Justice Nkabinde. Our difficulty is this. If it doesn't get the money from Treasury, with the best will in the world, my client doesn't have 11 billion rand that it can pay out of its own financial
No,
resources.
I'm saying, let's assume Treasury is going to make money available, is willing to make money available, but there is no contract.
Yes.
Will CPS, taking into account its constitutional obligations that you've spoken about, be willing to execute?
The answer I was trying to give was to say it would, with respect, be extraordinary if Treasury paid 11 billion rand into my client's account at a time when there was no contract in place. It may do so, and perhaps I would be surprised, but it would strike me as being enormously imprudent for Treasury to pay the money into my client's account when there is no contract telling my client that it must now pay the money to grant beneficiaries.
But it would with a court order. If there is a court order, it would, wouldn't it?
It would what, Chief Justice?
It would, Treasury would pay money into your client's account. And Treasury and SASSA will ensure that money is paid into your client's account.
My client is in a position to discharge its constitutional obligation on the 1st of April, it will do so. That is the assurance I give you from the bar. The difficulty is how far backwards we go. And I keep coming back to the proposition where I really started. My client is in an unusual position where it cannot discharge its obligation unless it gets the assistance of Treasury, because it's ultimately paying over Treasury's money. My client is just a conduit. It's just the channel through which the money goes. But it needs the money from Treasury. And so we keep coming back into something of a loop. Does my client need a contract? And our submission is my client would need the assurance of that contract.
Let me just make sure that I understand the essence of your client's position. We and SASSA have a contract ready to be signed. Constitutional Court authorizes to sign that contract. That will be the end of the matter. Is that it?
I'll take an instruction, but I would expect the answer to be yes, Chief Justice, because that's what my client says on affidavit. It says we were ready to sign the contract we had agreed with in principle. The sticking point then is the ministerial task team says the whole process is unlawful. If this court can legitimize the process, I can see no reason why my client would then not conclude the contract on the terms it had agreed in principle with SASSA, and I've just received the instruction it would do so, Chief Justice.
I was summarizing what I thought was the essence of your client's case. I was communicating what I thought is what your client really wants. So I'm right.
I'm sorry, Chief Justice, I couldn't hear, and I apologize. I couldn't hear the last part of the
My
question.
summary of what I perceive to be your client's position is correct, as confirmed by that note.
My client wishes to have a contract after the 1st of April to protect it, and its desired price in that contract is the one it has already negotiated with SASSA. On its affidavit, it says it's the current price subject to a CPI adjustment from the 1st of April 2017 for the anticipated 2-year contract. That is my client's position, Chief Justice.
And that's how much is it 16 rand, 17 rand?
Chief Justice, I need to answer there is no short answer to that question.
No, it's okay. If there is no short answer, then it's fine. I I thought you were in a position to say it's 16 rand, it's 19 rand, it's 18 rand, and so on. But
Justice,
if there is no short answer,
But
I
it's important
understand.
for me to tell you why there is no short answer. The existing contract is a payment per beneficiary. In the new draft interim contract my client negotiated with SASSA, the payment is a lump sum per month. In other words, it's a payment per month, a lump sum, not a payment per beneficiary. That's the important difference.
What is the difference between the lump sum before and the lump sum now per month?
No, there wasn't a lump sum before. Remember, under the old contract, it was a payment per beneficiary.
No, but you can add up the numbers and arrive at the lump sum.
And that's what my client has done. So, Chief Justice, that is exactly what my client has done. So when my client says on affidavit, the current price, the price in the interim contract draft is the current price subject to a CPI adjustment from 1st of April 2017 for the anticipated 2-year contract. That is what it has done. It has calculated the number of beneficiaries that it anticipates will be paid over the next 2 years on a straight line basis. It has worked in CPI, and that's how it has come up with the number. So, Chief Justice, why I can't give a short answer is the sum you'll see in the interim contract is not per beneficiary, and I need to make that plain. But what my client says on affidavit is that's how the sums were done.
Mr. Cockrell, so you don't have the two figures, the old lump sum, even if based on per beneficiary, and the new lump sum. You don't have those figures, because I think that is what the Chief Justice is trying to get to.
No, I understand that, Justice Badlanga, and my answer is that you won't find the same firm price in the two contracts. In the old contract, you'll find a firm price per beneficiary, and you have seen the number. It's referred to in the papers. It's 16 Rand 45 or something like that.
I had given up, but now my brother has resuscitated my... Let me make the last attempt. Every prudent business entity would know this is how much I make from this deal per month. So I expected of your client to be able to say, on the old contract, this is the sum total of what I made per month from SASSA, and on the negotiated contract that has not yet been signed, this is how much I would make per month from SASSA. That's all I was asking for.
And Chief Justice, the answer is this. In relation to the old contract, you will get those numbers in due course, because that's what this court ordered in All Pay 2. At the end of the contract that expires on the 31st of March, I believe it's within 60 days, my client has to give you audited statements of its income, its cost, and its profit. So you're going to get that. Our learned friend, Mr. Untelter, said unkindly, why don't we give you the numbers now? Well, we can't do it because the contract hasn't run its course, but this court will get the numbers in due course. And in relation to the draft interim contract, Chief Justice, I need to make my position absolutely clear. All I'm saying is, if you go and look at that contract, you'll find the price is done in a different way. And I wouldn't want anyone to say that I was trying to mislead the court in that regard. My client's explanation is on affidavit, but the numbers have been arrived at on a globular basis per month, rather than on a per beneficiary paid basis.
Mr. Cockrell, the issue of us getting the figures down the line is a different issue altogether. That's the accounting process that I think in terms of All Pay 2 we require, and which some of the parties are insisting on. But what we are asking for now is something totally different. It is, we want the lump sum payment in terms of the current contract and the lump sum projected payment in terms of the in-principle agreement that has been shelved thus far. That's what we are asking for. The two are totally different. Us getting some figures down the line, that's totally different, and that's not what we're asking for.
And
In other words, how much has CPS been banking per month from SASSA? And how much will it now be banking per month from SASSA? That's all.
And Chief Justice, we can do those numbers. I don't have them available, I'm afraid, but I can take an instruction. I'm told I could get the figures within a short period of time, but as I stand here, I don't have those numbers, obviously. What I can tell you is what I've told you. What was the price in the old contract and what price you'll find in the interim contract.
That's fair enough, Mr. Cockrell. Thank you very much.
And so, Chief Justice, where it goes is this. Let me try and summarize the lines of the debate, certainly as I understand it. This court has two ways in which it can direct my client to continue performing after the 1st of April. It can ask for an extension or direct an extension of the contract, or it can direct a new contract. No matter which of those strategies it adopts, it's going to be confronted by two issues. One, what is the term of the new contract or the extended contract? What is its duration? And number two, what is the price? Now, on the term, the duration of the new contract, I understand there to be consensus that it should be at least 12 years. At least 12, at least 12 months. It should be at least, it should.
I raised the 12 years hypothetically, Mr. Cockrell.
I'm sorry, Justice Matlanga this morning mentioned 12 years in a hypothetical example, but obviously it's 12 months. I understand there to be agreement about that. The outstanding issue then becomes the price, and the debate seems to be this, as we understand it, Chief Justice. Does this court tell my client what the price should be, or does it leave the parties to negotiate what the price would be? You have my submission. We say in the first instance the parties should be left to agree on the terms, but if you're against me on that, the submission we would make is what this court should order my client to do then is to conclude a contract on the price that has been agreed between my client and SASSA in the draft interim contract, rather than on the old terms. And Chief Justice,
which we don't know. How can we just authorize you to agree on a price which you are not telling us? We know the old price. We know the old price.
But Justice Mojapelo,
we know the old price, which is per beneficiary.
Yeah.
But if you say we should authorize you to enter into a contract on a price which you haven't given us, you're asking for a blank check.
Yes. I'm not, because what
Considering that Mr. Unterholt, I think it was, said the total amount per month that CPS used to get from SASSA was around 800 million. I hope I'm not mistaken. And that is going to move no, that's over a period, I'm sorry. That's over the whole period. And then it'll end up being 1.2 billion. Okay.
Chief Justice, can I try and be as helpful as I can? Because that really is my...
Confine yourself to my brother's question.
But I would like to be as helpful as I can. So when I was asked by the court, what will we find in the draft interim contract? My response was, you're going to find the price is done in a different way. If the court is now asking me to disclose that interim contract, again, I will take an instruction from my client, but it's not my intention to hide anything from this court. The submission I make in law is the court should, if it were minded to direct the conclusion of a contract, rather than to leave my clients at large to conclude it with SASSA, then it should direct it on the draft terms, not on the old terms. That's my submission. Justice Mojapelo says, but we don't know what the new terms are, and I must then take an instruction.
You basically are saying to us, the new price is the old price, but subject to CPI.
Going forward.
Well, why can't that be the formulation? Why do you want the bulk amount? Why can't we just formulate it like that and it's not the bulk amount?
Can I give you the answer to that?
Yes.
Sorry, it's an important question. At the moment, my client is paid per beneficiary. In other words, for every payment it's paid 16 Rand odd. I think it's 16 Rand 50. The concern for my client is this. The new contract will not be a 5-year contract or a 12-year contract in my slip of the tongue. It's going to be a stopgap contract, an interim contract. And so at the end of that period, various beneficiaries are likely no longer to be paid by my client. They're likely to move to the new service provider. And so the concern for my client is if at the end of the year it's left with only one beneficiary it has to pay, it still has the same infrastructure which it has to provide for. And so, as I understand it, these are my instructions, that's why the new contract, the stopgap, the interim contract, is done on a globular amount rather than on a per beneficiary basis. Precisely because my client has the same overheads, whether it's paying 17 million people a month, or 1 million people a month, or one person a month.
How can that be? Don't you now in the villages need transport that is going to take the money to a particular village for the old people to get money? Now, if there are no people in that village to pay, what is the transport for? What are the staff members that are going to be paying, employed for because they've got nothing to do? How can it be the
With
same?
respect, that's correct, but the back office costs, if I can put it that way, the costs of the infrastructure that makes the payment possible, those infrastructure costs are the same, whether it's 17 billion people being paid or 1 million people being paid. But Chief Justice, that's my explanation. I understand. The court says to me, why is the price done different in the new contract rather than the old one? The old one was on a 5-year basis. The interim contract is expressly a stopgap. And that's why you'll find different.
But you understand, Mr. Cockrell, as was the case with Mr. Breitenbach. Are you listening to me or to your junior?
I'm sorry, Chief Justice, I'm trying to get an instruction on the issue.
You understand, as was the case with Mr. Breitenbach, that we need help from you people to explain to us in a language that we can understand what is happening.
Yes.
And I'm not too sure that you are doing enough to help us understand your difficulties.
And then I've been remiss, and I apologize, Chief Justice, because I understand my task today to be to try and explain to this court precisely what the practical difficulties are and what the solutions are going forward. And I apologize if I haven't discharged that obligation, but certainly my intention was to be as helpful as I can.
Why can't it be 12 months?
Chief Justice, we don't say it can't be 12 months. I understood the consensus to be on 12 months, but it's no part of our submission that it can't be 12 months. The only thing my client would want is, at the end of that, it would want to know that that's the end of the contract for it. And so SASSA needs to be confident that it can put in place a competitive tender process before the end of the 12 months. Chief Justice, I apologize. I was talking to my learner junior because I was trying to get an instruction on this issue. We tended to make the draft interim contract available. It will formally need the approval of SASSA because they're the other contracting party. But from my client's perspective, it tenders to make available to this court the draft interim contract, the commercial terms of which were agreed between my client and SASSA before the ministerial task team said that the process must end. So in response to Justice Mojapelo's question and in response to your question, Chief Justice, why is my client not being more helpful? I'm not sure I can be any more helpful than that. The affidavits tell the story of how the contract was concluded. It's a draft contract because the parties can't sign it because of the concerns about the legality. We will make that contract available to the court. If the court is minded to direct my client to extend the contract or to conclude a new contract, then our submission would be, it should be on the terms that were agreed between the parties. If the court is against me on that, then you will direct them to conclude on some other basis. But I believe it answers Justice Mojapelo's concern, was he said, I'm asking for a blank check. And it's no part of my brief to ask for a blank check. We tender the interim contract.
If we were to take you up on your tender, is it fair to assume that as we receive that draft, we would also be receiving a sum that represents the globular amount that CPS used to receive from SASSA on a monthly basis?
In other words, can I check I understand, Chief Justice? You're talking about the historic figures. In other words, the 16.50 rand, if I can round off per month, you want to see what income my client earned historically during the period of the contract.
Yes, per month. This is how much per month?
Can we tend to that? I'll need an instruction, Chief Justice. I can't answer.
Compared to this much per month that the new or the proposed new contract would enable CPS to generate or to earn per month?
Well, you'll see in the new contract what the globular amount is, so you'll easily be able to compare it to what the historic figures have been on a monthly basis. I don't want to detain the court, Chief Justice. It's not a legal submission, so I can't answer that without an instruction, but I will wait for the instruction. Chief Justice, I believe I've covered most of the terrain I wanted to cover, and I've overstayed my welcome quite considerably. I had been intending to say something about freedom under law, Black Sash, Post Office, and Corruption Watch, but in the light of the way the debate has moved on, I don't believe it's necessary for me to address that. You have our heads of argument, you have our position as a matter of form in relation to the various prayers sought by those parties. And so, Chief Justice, all it remains for me to say is in relation to costs, my client doesn't ask for cost against anyone. I don't believe anyone asks for cost against my client. So my client is not on the hook for costs and doesn't ask for costs from any other party. What I do owe you is an instruction on the issue you've asked me about, which is the historic numbers. And could I come back to you, Chief Justice? I don't want to hold up my learned friends who I'm sure have things to say. Chief Justice, I have the instruction. I'm told that my client will make those numbers available. May I just ask you for 30 seconds to check that I haven't missed anything, Chief Justice, before I sit down? Chief Justice, those are our submissions. It had been my intention to be as helpful as I can, and I apologize if the court is of the view that I wasn't helpful, but it really had been my intention to offer all the assistance I can, and I'm indebted to you for the indulgence in relation
Thank you very much, Mr. Cockrell. Mr. Tsatsawani?
May it please the court, Chief Justice. Chief Justice, you will have seen in our papers that we only came here to deal with the relief that Black Sash sought to pursue in paragraph 5B and 11B of its notice of motion. And you heard Mr. Badlander this morning indicating to the court that they are no longer persisting with that relief, and that they are covered as far as the relief sought in paragraph 5A and 11A is concerned. So that deals with the reasons why we came to court. The only issue that we want to raise with the court for consideration is the whole question of ownership of this information, because Mr. Badlander's client's concern was that this information is being disseminated and people are using it for not necessarily for the purposes for which it was intended. And that is why they wanted the declaratory order to the effect that at the end of this process, the information belongs to SASA, and that is what we object to. And they accept that the information cannot belong to SASA. But the question remains whether or not this court needs to express a view on the ownership of that information. We submit that the court does need to express a view, regardless of the fact that the relief is not being pursued, because it is going to remain a live issue. This information is going to be disseminated, and the beneficiaries are going to require protection. And the protection is now provided for in the Protection of Personal Information Act. And there are remedies which are provided for in that legislation. But those remedies are available to a person that is referred to therein as the data subject. That person has remedies on their own, and they also have remedies which they can ask my client, the information regulator, to pursue on their behalf. So we will submit that the court should express a view on that particular point as far as ownership of that information is concerned. We submit that it belongs to the data subject as defined in Section 1 of the Act. And if that is expressed in the court's ruling, then that will assist in particular as far as the functioning of my client is concerned and in helping the beneficiaries of these grants. Those are our submissions, Chief Justice. As it please the court.
Thank you, Mr. Tsatsawani.
As it please the court.
Mr. Badlander?
Thank you, Chief Justice. There are only three matters which I wish to address. The first is the vexed question which has been debated at length today about how to deal with the question of extension and suspension of the contract. We submit that the mere extension of the suspension of the declaration of invalidity beyond the terms of the contract will not result in a contractual obligation on the part of CPS after March 2017. It will have no contractual obligations after March 2017, and the fact that the declaration of invalidity is further suspended doesn't create a new contractual obligation for CPS, because the contractual obligation ceases on the 31st of March. So the question really is, what is it that would bring about an obligation on CPS beyond the 31st of March 2017? That's really the matter with which we've all been grappling today. We submit that the starting point is to recognize, as one of our colleagues said, that the CPS obligation going forward is a constitutional obligation, not a contractual obligation. And it's a constitutional obligation. To repeat myself briefly, it arises on two bases. Firstly, on the basis of All Pay 2, because in All Pay 2, this court held that CPS is a quasi-organ of state, can't simply walk away even after the contract comes to an end. So that's one basis. The second basis is the basis put to me by the acting Deputy Chief Justice, which is Section 8, Sub 2 of the Constitution, and the judgment of this court in Juma Masjid, where the court dealt with the obligations on private parties arising directly from the Constitution, horizontal application. And we say, we've made the submission, I'll just repeat it briefly. If you're the only person, if somebody has a constitutional right, and you're the only person who can make it possible for that person to achieve his or her constitutional right, then you have an obligation to enable it. If the achievement of a constitutional right is dependent upon you, you have an obligation to enable it, certainly where you have been the person responsible for giving effect to it up to now. So the question really becomes whether it's on a Section 8.2 basis or on the basis of quasi-organ of state. The question then becomes, there is a constitutional obligation, and we all seem to be ad idem on that. CPS agrees that it has a constitutional obligation, I think on both bases. But in any event, we agree that there is. So the question then becomes, what is the content of the constitutional obligation? What do they actually have to do? And we say that has to be specified. And we say it can be specified in one of two ways. One way it can be done is that the court can order an extension of the period of the contract. The court can say, having regard to the rights of social grant beneficiaries, and having regard to the continuing constitutional obligations of CPS, and having regard to the obligations of SASA, we order that the contract be extended for a specified period. If that were done, then the suspension of invalidity would need to be extended, because otherwise you'd be ordering...
Would need to be or wouldn't need to be?
Would need to be extended, because now one's relying on the contract, one's saying extend the contract, and in that event, the suspension of invalidity would have to be extended. And my learned friend's point about All Pay is, with great respect to him, really without substance. All Pay knows all about this case. Everybody knows about it. All Pay didn't bid for the tenders which were put out, and All Pay hasn't chosen to enter in on this case. It has no interest in the matter. No conceivable interest as to what happens going forward. It isn't a contender. But there's a simple way of dealing with it. You can suspend the declaration of invalidity without referring to All Pay. You can say, we see that in All Pay, we suspended the declaration of invalidity up to the 31st of March. Today in Black Sash, we extend it further for 1 month, 6 months, 12 months, or 12 years. And so you don't have to amend the extension order or the suspension order that was made in All Pay. You make a new suspension order. And so the All Pay point really, with respect, is without substance. So that's one way in which the court could do it. The court says having regard to all of the obligations involved and the rights involved, we order an extension of the contract. We suspend the order of invalidity for the period of extension. And then the question becomes the how much, which the Chief Justice has been raising.
So the two work together.
The two work together. And then the only question becomes how much, and I'm not going to re-engage on that. The court has been adequately entertained by my colleagues on that. And it's not a matter on which the Black Sash has made submissions. So that's the one way to do it. The other way to do it is to say, well, we're not going to extend the contract. We are simply going to order SASSA and CPS to continue to carry out the obligations which were reflected in the old contract. We don't order them to enter into a new contract. We don't order an extension of the new contract. We just say for the next 1 month, 6 months, 12 months or whatever, the parties must continue to carry out their obligations under that contract. Then you don't even need a suspension of the order of invalidity.
So you must look, they must look at the same contract that is not, that has come to an end for the purpose of knowing what is required of them.
Yes. But those are the two options, and it may be that the most, as Justice Cameron suggested, the most candid way to do it is the first one, to say that's actually what we're doing, the truth.
I think there is candidness either ways.
Yes, as long as you say what it is and what you're doing, people will understand. Of course, in both instances, this would have to be subject to the protection of personal information, which we've asked for and which has been agreed. So those are our submissions as far as the question of suspension and extension are concerned. Then I need to respond very briefly to my learned friend's, Mr. Breitenbach's remarks, and I'm sorry to have to go back to the Portfolio Committee of the 30th of November 2016, but I do need to go back there because that goes to an important question, which is a breach by the Minister of her constitutional obligations. What happened at that meeting is evidence of a breach by the Minister, and a serious breach. And the breach arises in this way. Under Section 55(2) of the Constitution, the National Assembly...
I missed out which section?
55 sub 2 of the Constitution says that the National Assembly must provide for mechanisms to ensure that all executive organs of state in the national sphere of government are accountable to it, and B, to maintain oversight of the exercise of national executive authority, including the implementation of legislation and any organ of state. So there's an obligation, the constitutional obligation on Parliament, on the National Assembly under Section 55(2) to exercise oversight in this matter. And if one then goes to Section 92 sub 3, one sees that there's the obligation on the members of the Cabinet to enable Parliament and the National Assembly to do this job. Section 92 sub 3 says members of the Constitution must be, 92(3)(b), provide Parliament with full and regular reports concerning matters under their control. And the purpose of that is to enable the National Assembly to carry out its Section 55 obligations. And what happened in this matter was that the Minister grievously misled the Portfolio Committee of the National Assembly. And she and SASSA both did that. It's set out, I'm not going to go to all of the detail, can I just remind the Court, it's on page 41 of the Black Sash papers, paragraph 94, where the deponent says SASSA, and it's also the Minister, did not, it refers to the contract, to the opinion which was received from Advocate Trengove and others in October, where they said, we've been told by SASSA will not be ready to take over the payment function in March 2017. We require more time, years rather than months, to put in place new system in place, and SASSA had no choice but to enter into an interim arrangement with CPS and proposed to do so. That's what the Council were instructed. That's SASSA's intention. There's not enough time to run a competitive bidding process for the appointment of a new contractor in time to take over after March 2017, and there was nobody else who had the necessary infrastructure in place to perform the payments function or the core components of it by March 2017. It would also not be feasible for anyone else to create their own infrastructure without a long-term contract to recover its costs. That's what Ms. March says. In paragraph 94, she says, SASSA and the Minister didn't inform Parliament of this, didn't tell them. The Minister has had the opportunity to answer that, and she hasn't. We are told in our learned friends, in affidavit in response to the last instructions by the Chief Justice, that the Minister says, or the CEO says and the Minister confirms, that there was reference made to the difficulty of that the biometric process wouldn't be ready by the end of March. But that's all that's referred to in the answer to the questions from the Chief Justice. And so there's been an opportunity to answer this. It hasn't been taken. And the fact what flows from this is that the Minister and SASSA have frustrated the Portfolio Committee in the exercise of their constitutional functions. They've acted in breach of their constitutional obligations, which are, of course, obligations not just to Parliament, but to us, the members of the public. That's how we hold members of the executive accountable, by being told through Parliament what's happening. And it's a serious matter, and I submit a matter which calls for comment by the court. That brings me to the final question.
In that event, Mr. Buckland, will a declarator be appropriate?
Yes, Justice Nkabinde.
I'm
So
sorry,
simple that one can answer a question with one word. I'm very glad to have that chance.
Mr. Budlander, that wasn't part of the relief sought. Wouldn't it be fairer that if we consider saying anything about it, to issue a rule for the Minister and other people to respond to it?
I would have no objection. We would have no objection to that, Justice Frenneman. Let's see what the explanation is. That brings me, Chief Justice, to the third and last point which I want to address, and that is the submissions of our learned friend, Mr. Cockrell, who says, why do you want to second-guess SASSA? We, CPS and SASSA, have reached an agreement. If you're going to tell us to enter into a contract, tell us to do it on the basis that we've agreed. Trust SASSA. Well, why would we want to second-guess SASSA? With due great respect, and I don't want to be offensive, but the reason is the history of this matter. The reason is that there is not reason to have confidence in SASSA's judgment. SASSA has made commitments which it has not met. It has failed to perform its tasks adequately or at all. It has failed to explain its conduct adequately. And that's a systemic problem. One doesn't take any pleasure out of it.
It entered into an illegal contract in the first place.
And they entered into an illegal contract to start with. One takes no pleasure in saying these things, but they are realities which we all have to face. The other reality which you have to face is SASSA has a CEO who has lost the confidence of the Minister. The Minister has been very critical of the CEO in her last, or actually only, affidavit. We have no idea how long he will last and who the next one will be. And so we have an undetermined leadership going forward of the CEO, but someone at the Minister says is no good for the job. And then SASSA is subject to the supervision of a Minister who has demonstrated, and again to put the matter very politely, has demonstrated that she's not someone who keeps her finger on the pulse, to use the Chief Justice's phrase. She can't be relied upon to ensure that SASSA enters into a proper contract. And all of this is underpinned by the obvious question, what is the full, I'm not suggesting the court is being misled, but why is it necessary to shift from a per beneficiary calculation to a lump sum calculation when this is going to be a short-term contract? Everyone seems to agree it's going to be a short-term contract. It might be different if it were proposed that this were a long contract, and at the end of the contract, someone else will take over the whole job, and that person will be phased in towards the end of the contract. Then one can understand the CPS argument. But everyone's talking about a short-term contract for 12 months. In 12 months, no one else is going to start taking over this function. SASSA has told you, and has told its counsel, that it will take years for this to happen. And so if in a 12-month period, there is no realistic prospect that there will be any significant takeover of beneficiaries, and therefore significant reduction in the lump sum received by CPS, it is a chimera in the context of a short-term contract. In a long-term contract, it might be different. So we would respectfully submit that the proper basis on which, if the contract is going to be extended, and as I say, everyone seems to think for a period of 12 months, it should be extended on the basis of the existing rates, and CPS should have leave to make an approach to the court for an adjustment on a basis which can then be debated in due course. But to start at the outset with the increased rate we submit would be the wrong approach. And can I finally say in this regard, a learned friend has said a couple of times, and CPS say in their papers, you know, this was a contract we entered into in 2012. It was for 5 years, and we haven't had an increase since then. That, with respect, is somewhat misleading. They entered into a contract for a 5-year period, obviously knowing that their costs were going to increase over the 5-year period. And one will expect that they knew it was going to cost them 12 rand in the first year, 14 rand in the second year, 16 rand in the third year, and so on and so on. And so they made a price, an overall price, to average the cost and the profit over the period. But to suggest that these are 2012 prices is, with respect, completely wrong. It's a 2012, 13, 14, 15, and 16 price, which they were very happy to accept in 2016. Those are our submissions, Chief Justice.
Thank you, Mr. Bartlander. Mr. Winterhalter. Yes, Mr. Winterhalter.
As the court pleases. If I may first just make a few brief submissions in respect of the scope of the court's remedial powers and reference for the court the Electoral Commission and Mhlope, a recent case decided in this court where at paragraph 132, in commenting on the scope of section 172(1)b, the court says the following, which seems appropriate to the circumstances of today's case. The section clothes our courts with remedial powers so extensive that they ought to be able to craft an appropriate or just remedy even for exceptional, complex, or apparently irresoluble situations. And it does appear that if that is the remedial remit that the court, with respect, justifiably understands for itself, then some of the rather fine distinctions that have been debated before the court in the course of the day should ultimately be understood against that very wide power to effect a just and equitable remedy. The two proposals that in variances have been debated throughout the day is an extension of the existing contract, or, as it might be put in different permutations, the court determining the incidence of the duties that rest upon CPS and SASA by reference to a contract, whether it be the existing terms of the contract or some variance of it. Now, there's something to be said for one or other way of doing the remedial work that has to be done. The difficulty, as I understood Justice Cameron in respect of the extension, is that the very contract that is sought to be extended is of a fixed term and, unlike legislation, is bounded, and therefore there might be understood to be a guillotine. It may, however, be that under the reasoning of this court in various cases that the conditions attaching to variation would include variances of the underlying contract in this position. But from the perspective of coming to an outcome that is the right outcome, it can as readily be done through determining that the incidence of the obligations that rest upon CPS will be done not by creating a contract as if it were a private law act of permission or enablement, but simply to determine the terms upon which that obligation will be discharged. And that can be done in various ways and with various levels of detail, as, for example, what Treasury must do to transfer the money and the like. But it's the incidence of public law obligations that are being regulated by the court. What our learned friend for CPS sought to invite the court to do was adopt a different model, which was to say the order should go no further than to order CPS and SASA to enter into negotiations for a contract. And that, of course, was done, as I think he candidly acknowledged, for the purposes of having greater freedom to increase the price at which that could be done. Now, in our submission, there is no warrant whatever to adopt that model, and for a few reasons. The first is that insofar as the court is making an order as to how the obligation will be discharged, we have submitted and submit again to the court that the no benefit rule is the right rule. A state agency now being reminded and required to discharge state obligations must not profit through the exercise and discharge of those obligations. The no benefit rule is the right rule to apply. Our learned friend for CPS, however, wants something different. He wants a different criterion. He wants a criterion of reasonableness. So what is being the court is being invited to consider is that there should be a standard applicable to SASA and CPS that will be judged on the basis of are the terms reasonable. But we would submit that that is a very vague criterion for the purposes of trying to work out whether, from a public law perspective, that is the right incidence of the obligation in respect of price. Because what is a reasonable price? Is it a fair rate of return on commercial terms? Or is it what a state entity would do? We say the no benefit principle is the right one. And then implicit in the reasonableness standard are these further questions that are going to arise, which is...
Maybe before you go to the further questions, on that point, would you agree then, and I assume you do, with Mr. Bartlander's submission to the effect that CPS would have factored into the price the inflation issue?
Yes.
I raise it because counsel for the CPS said, no. Computers prices go up and up and up. But Mr. Bartlander has just made an issue that never occurred to me, and that is, but you know that the prices are not going to be static. You project into the future when you fix a rate or a tariff per beneficiary to accommodate the possibility of prices of whatever you need to carry out your mandate, including even possibly salaries of employees and amounts payable to those you might also have to outsource to being increased.
In our submission, our learned friend Mr. Bartlander is absolutely right. One must distinguish revenue projections and cost projections. When CPS reckoned on the 16 Rand 44, it was reckoning on a revenue projection over the life of the contract that, taking all the escalations in costs into account, would still leave it with a margin. We don't need to debate and can't even speculate as to what that profit margin has been over the period, but suffice to say that you can't simply analyze the cost components and the increases in cost that might have occurred over the period, because they would have been reckoned at the inception of the contract, and you need to contemplate both what revenue was projected and what cost escalations were. And that is why coming to the 1642 is not oppressive to CPS. It falls in line exactly with their commercial judgments as to where they could profitably stand at the end of the contract, which is where we are today. And the overwhelming likelihood is that they are in a profitable position at the end of the contract, because that's what a commercial person would do to ensure sustainability over the life of the contract. And that is why Mr. Bartlander is, with respect, absolutely correct.
But what about the proposal or the submission that, assuming that the markets have behaved in an unpredictable way, with the result that they may have failed to take into account the unexpected that happened?
Yes.
Should they not be permitted to make representations that could accommodate that possibility objectively?
Yes. Chief Justice, there are two submissions we make as far as that is concerned. For everything that CPS says, the one thing that they do not contend is that their current position is a loss-making one. They're a listed firm which has management accounts that are entirely up to date. If they were in a loss-making situation, they would be the first to tell the court that that is so. But that there should be a safeguard to ensure that should, for some unexpected reason, some aspect of cost has not been properly calculated, if you simply maintain the status quo, we would have no difficulty that they can come back and approach either the court or Treasury as the court determines to motivate why unexpected cost escalations have led them into a position where they're not. It's not that they're less profitable, but that they would make a loss, because we accept that we can't expect them to discharge a constitutional obligation and make a loss. That would be entirely unfair. Could I also just submit, though, that the court said CPS might wish to place before the court what its expected revenues are. The court should also ask them to show what their costs have been, because it's only the comparison of revenues and costs that ultimately show you where they are profitable or not. It's no good just looking on the income side of the statement. One has to look at, obviously, the cost side as well. We have also, in the course of hearing our learned friend in respect of the position of all pay and whether there could not be a variation because its interests would have to be taken account. I asked my attorney to make contact with their attorneys, and the answer is they have no interest. So that procedural objection need not detain the court for any time at all.
Can we take that into account? Or should we rather find our way through the law?
My learned friend
because
raised it as a...
I don't know, someone else like Mr. Cockrell may want to depose to an affidavit countering that.
I very much doubt that it will ever be in contention that we didn't contact Allpay and ask whether they retained any interest in a variation to the order. The instruction I have is that they have no interest, and the court need not be detained by that point.
Attorneys have instructions from their client to that
Exactly.
effect.
Exactly. The client, Allpay, the client, has no such concern. Could I just, in respect of our learned friend's alternative, his first was allow us to negotiate and trust SASA and CPS to come up with terms that are reasonable. And then the criteria would be this very loose criteria of reasonableness, which would then be judged ex post facto by somebody or other in due course as to whether it was or was not reasonable. That is a recipe for a commercial freedom that we submit this court will not likely give its imprimatur to. But we would also just refer the court again to what our learned friend said. Well, we are now looking at, in terms of the interim contract, a lump sum arrangement not disclosed to the parties, but which will apparently now be disclosed to the court, and I assume the parties, which is predicated effectively upon the existing per beneficiary number, but with a CPI increased and then agglomerated into a lump sum. That's, as I understood, the methodology that underpins the interim contract that we haven't seen. But could I make this submission as far as that is concerned? In the papers, you already have an indication from SASA as to what underpins the methodology of the lump sum, which is that they want a lump sum for the purpose CPS rather, wants a lump sum because over time of an interim arrangement, there will be a paring down of the services rendered. So they want to be able to peg the revenue at a level on the predicate of services rendered at point A and retain that revenue even though their services will be tiered down over time. Now, exactly that proposition is to be found, and an example of it is given in the papers in the letter of the 28th of December 2016, which is in paragraph C, and in my pagination is 25G. But it explains exactly how this fixed fee is going to be related to the tearing down of services. Now, if that were to be the case, we would submit that that would give very considerable scope for making quite considerable profits, because at a lump sum rate on an escalated CPI basis, they would practically be speaking not be going to the remote rural village to deliver cash because somebody else, SASA or another provider, would be providing that service. My learned friend says, but there are fixed costs, and he's correct, there are fixed costs. How many of them are already sunk costs and wouldn't have to be added to, we don't know. But there are many costs which are variable costs. Filling up the vehicle to go to the village to deliver the cash is a variable cost, and it would not be incurred. So all of this is to say these are matters that ultimately this court should not have to trouble itself with, save to say that the notion that one would give, as it were, the power to SASA and CPS to evolve formulae, which they will then use for the purposes of contracting, would be to give a freedom which we do submit is simply unwarranted. And the court should rather take the contract as it exists at the moment and say those are the terms on which the obligation will be carried out. And if CPS has a difficulty, it can approach either the court or Treasury for variation. Those are our submissions.
Thank you very much, Mr. Unterholter. Judgment is reserved, and the court will adjourn.
Please rise.